Good morning, everyone. Thank you for joining us today. We will continue our exploration of the European Union Artificial Intelligence Act, also known as the AI Act. I am Marion Audat, law professor at Artois University, France. I have the great pleasure to organize this webinar with my colleague Arnaud Latil from Sorbonne University. He moderated the first webinar on the architecture of the AI Act 1 month ago. And actually you can watch or replay this webinar on the European Commission's YouTube channel. We are broadcasting today from the Direction General Connect, in charge of digital policies within the European Commission in Brussels. DG Connect hosts the EU AI Office, and I have the great pleasure to welcome members of the AI Office with us today to explore the AI Act. They all have a strong background and expertise in AI governance and regulation in EU jurisdiction and beyond. Jordanka Ivanova, welcome. You are Head of Sector for Legal Oversight of the AI Act implementation at the Regulation and Compliance Unit, and you have been involved in the AI negotiations from the start. Then we have with us Friederike Grosse-Holz. You are technology specialist in the AI safety unit, and I heard you freshly arrived at the AI office to work in this new unit. And finally, we have Antoine Alexandre André. You are Legal and Policy Officer from the AI Innovation and Policy Coordination Unit, and you have been working on the AI Act, notably from a standardization and implementation angle. Thank you very much for being with us today. I briefly mentioned that this webinar is part of the AI Pact. So this is an initiative launched by the European Commission in May 2024 to directly engage with stakeholders and to support them to implement the AI Act. Today, we will focus on 3 main topics. First, we will discuss obligations for providers and deployers to be implemented by February 2025. Second, we will analyze the regulation of general purpose AI models. And finally, we will have some discussion on the requirements for high-risk AI systems and the related standardization process. We really aim to make today's agenda interactive. So after each of the 3 parts of this webinar, we will take questions from the audience. And for that, we are using the Slido application. So normally you can already see on your screen a QR code, and feel free to connect to Slido and participate. Let us start with the AI Act obligations. So the AI Act is being implemented gradually, depending on its provision. So maybe, Jordanka, you could provide us with a general overview of the AI Act's implementation's timeline.
Thank you very much. Indeed, the AI Act is going to become applicable in a staged approach, so we give enough time for the providers, deployers of AI systems to gradually adapt to the relevant provisions. So the general application timeline for the AI Act is 2nd of August 2026. When the whole regulation will start to apply, but we have also certain provisions that will become earlier into application. And the first one are the prohibitions and the so-called AI literacy, which providers, deployers of AI systems will have to develop within their organizations. And this will become applicable as of 2nd of February next year, 2025. Then, as of 2nd of August, 1 year after the entry into force of the AI Act, also the governance framework and the enforcement provisions will start to apply. So that means that the member states will have to designate their competent authorities, notifying authorities to take responsibility for different procedures, and also there will be the enforcement provisions that will become applicable with the exception of the fines for general purpose AI models. And importantly, also at that moment, 2nd of August 2025, also the provisions for general purpose AI models will start to apply. And then, as I said, next 2026, we'll also have the main scope of the AI Act with the key requirements and obligations for high-risk AI systems, in particular those that are standalone with fundamental rights implications listed in Annex 3 that will start to apply, as well as the transparency obligations for certain AI systems related to obligations to notify individuals or related to AI-generated content. And the final and last deadline for the application will be in August 2027, where we'll have a bit more time also for the specific rules for AI systems embedded in regulated products, such as machine, medical devices, and others that will also then become applicable as of 2nd of August 2027. So we have also more time for this sector to integrate and adapt to the provisions.
Thank you very much for this very comprehensive response. From there, maybe we can go into more detail with obligations. First, regarding the scope of the AI Act, we need to come back to the AI systems definition. It's very important. So could you, Jordanka, give us the AI definition, AI systems definition under the AI Act, and maybe tell us more about the inspiration followed here by the EU legislators in adopting this definition?
Yes, indeed, that's a very important element because it determines the scope of application of the AI Act, as this is our primary focus now. And the objective of the co-legislator has been really to develop a definition that is aligned to international approaches, so we can be converging also with the international community. And here we've also built a lot on the OECD work and the internationally agreed consensus what AI system is, and also importantly to develop a definition that can be sufficiently future-proof with these fast technological changes that stand the time, and we have a regulation that is adaptable and flexible enough by focusing on the key functional characteristics of the AI systems and adopt to the extent possible technique-neutral approach. So I have a slide where you see what are these essential characteristics and the definition of the AI system as defined in the AI Act, which is a machine-based system. It's designed to operate with varying levels of the autonomy, understood as the degree through which the system operates without human intervention that can differ depending on the different applications. It may exhibit adaptiveness after deployment, but this is not an essential characteristic, meaning that there could be systems that continue to self-learn during their use, but there could be others also that do not. It is a system that works for explicit or implicit objectives to achieve outcomes, and the essential characteristic is that it informs from the input how to generate these outputs. So this concept of inference at the design and development stage is very important to actually distinguish the AI systems from traditional software through this specific capability, how from the input and the data they manage to generate these outputs that could be different kinds of predictions, content, recommendations, or decisions, and they influence the physical and virtual environment in which the system operates. So we'll be providing further clarification based also on these essential components already framed in the AI Act.
Thank you very much. Maybe Frédéric, do you want to add to this and give us an example, for instance?
I can do that. Happy to do that. Yes. So I mean, if you look at the systems and models that are on the market today, a good example for an AI system would be, for instance, ChatGPT. ChatGPT is an interface where you can chat to an AI model. The model behind that interface can change, right? OpenAI has changed that from GPT-4 Turbo to GPT-01, and many people maybe didn't even notice. So the AI system really is the way the human interacts with the AI, and the AI model sits behind that. This can now obviously also be true in other cases. And then I think one thing that is interesting to note from a technical perspective on this definition of AI systems that we have on the screen is it could transfer to other paradigms. It doesn't only have to be large language models, right? So the co-legislators really have taken a pretty future-proof approach here to ensure that even further down the line, if there were ever other paradigms, that this would also, this definition might also still hold. So yeah, I think that makes sense.
Thank you very much. Let us turn maybe now to the stakeholders' consultation on the concept of AI system. This consultation was launched by the AI office last month, and it ended last week. So maybe, Jordanka, what were the main objectives of this consultation? And I would say, did you get what you expected in terms of number of responses, use cases provided, diversity? What can you share with us today?
Indeed, we organized this public consultation to gather stakeholder input to help us prepare, as I mentioned, future guidelines to further clarify the AI system definition, but also the prohibited AI practices that will become applicable as of 2nd of February. And we see that these concepts, legal concepts, are defined in the AI Act, but for us it was especially useful to get practical examples, use cases, and issues that providers, deployers, and other organizations are interested to see and get further clarity to understand, are there practical solutions in the scope, how these concepts are applied in practice. So this was very important, and we are very happy that actually we got a very diverse and useful input from about 380 organizations and also individuals from all types of categories, providers, deployers, business associations, but also public authorities, a lot of NGOs, academics, and also citizens, because we are also very impacted, and the purpose of this regulation is also to protect the citizens and our fundamental rights safety. So it was very interesting to see different examples for the system definition of concrete cases and also issues of these main components that will further now give us input to explain in the guidelines, and also to draw this borderline of what kind of systems are just traditional software, data processing, not falling within the scope, compared to these systems that fulfill the essential characteristics.
Okay, thank you very much for this preview analysis of the consultation result. Let us move on to the geographical scope of application of the Act. I think we are all aware of the global reach of the AI Act, but we could use a little bit more detail on this. Jordanka, could you provide us with the exact territorial scope of application of the AI Act? So very precisely, which operators are geographically covered by the text?
Yes, so we have the AI Act as a market-based legislation applicable to the whole European market, and we target providers and deployers of AI systems that are placed on the market, used in the Union, or have an effect in the European Union. So for the providers, these are the actors placing those systems on the market that can be established in the European Union, but they can be also in third countries as long as they place their AI system or also general purpose AI model on the European market. And for the deployers, we have organizations that are or also natural or legal persons who are deploying these systems and that are established in the European Union or located also in the European Union, and to avoid circumvention of the rules, because systems and also their outputs can still have effect in the European Union even if they are used outside. There is also a special provision which envisages that deployers and providers, even if they're established outside the European Union, when they provide input and that is intended to be used in the European Union and has effect here, could be also covered within the territorial scope.
Thank you very much. We can now discuss the first obligation applicable from 2 February 2025, AI literacy. So maybe Jordanka again, could you start by explaining the scope of Article 4 of the AI Act, so that is the provision on AI literacy, and maybe more precisely to which person this provision apply and what does it require?
Yes, that's a very important obligation, and it applies to both providers and deployers of AI systems. And it is a best effort obligation that, to the extent they can, they should ensure a sufficient level of AI literacy of their staff, but also other actors, persons that are acting on their behalf. And this applies both when they are developing the systems or also using them, with the overall objective to ensure this trustworthy and safe deployment and use of AI systems. It is very important to say that this is a very context-specific obligation, because here we can have very different expectations, also depending on the types of systems and solutions that are used by this organization. Just to give you an example, it's very different of what an organization that is just using minimal to no high-risk AI systems that are just doing summaries or simple translations, and compared to, for example, high-risk sectors where much more expectations in terms of knowledge, skills, and also understandings is expected to inform this self-development and deployment of the AI systems. And the overall objective is that this actually supports and takes into account the obligations also envisaged in the AI Act. So there is a clear link also with the for specific systems with human oversight and others, and aims to also ensure sufficient consideration of the impact on the affected persons and also the broader context, both to enable good understanding of the benefits and the usefulness of these systems, as well as the risks.
Thank you. It's very enlightening. AI providers and deployers may still wonder where to find some guidelines, some inspiration to implement this obligation, and maybe Antoine, you can help us on that.
Yes, I can. And actually, given the overarching nature of this specific provision, of this specific article in the AI Act, I can only encourage actually organizations to start thinking very early on about their specific approach to AI literacy. Okay. Basically, as Jordanka was saying, AI is a set of fast evolving technologies. Therefore, in the AI office, we do not consider that there is one-size-fits-all approach to AI literacy. And therefore, we want actually to stress that we need to consider this specific provision with a certain degree of, if I may say, flexibility. That does not mean, though, that AI companies have nothing to do, and that, or companies or organizations have nothing to do, and that actually the AI office and market surveillance authorities in the future will not act. But that just means that actually there is a need to further understand the exact knowledge, AI-related knowledge and expertise of European workers, and I would say even more generally of European citizens, to be able to fill potential gaps. But in practice and in short, I would say that the first thing organizations should consider right now is first to identify the different AI systems they are being used, they are using or deploying or developing, and then ask themselves actually several questions. First, what is the role of the organization in the value chain of that AI systems? So, meaning, are they a developer or are they a deployer of a specific AI system? And second, they should also think about the risk level of the specific AI systems they are using, developing, or deploying. Based on these assessments, they can then reflect back at their own internal AI literacy-related organization policies and think about potential additional AI trainings for those people, as mentioned by Jordanka, that are directly developing, deploying, or interacting with an AI system. In support of this, actually, the AI office is already taking actions. We have been already organizing one first workshop with AI Pact signatories, and we will be organizing very soon, actually in February 2025, a first webinar on AI literacy open to all, to really try to get first interactions with the community on the way forward with this specific provision. Based on these initial interactions with the community, we will be actually drafting and gathering all good practices that will then be widely disseminated. In addition to this, we are also discussing with member states within the AI board about guidance on AI literacy that should be published actually in the second half of 2025. And last but not least, this actually article and AI literacy encompasses actually lots of the things, notably including, for instance, the skills needed to interact or to develop a specific AI systems, but also it relates directly to the talents we manage to have in Europe. And so the next flagship actually strategy of the Commission, the Apply AI strategy, will directly include specific actions related to this in order to make actually the European continent a true AI continent.
Thank you for this very instructive response. Let us move maybe now on the second obligation applicable from February 2025, that is AI prohibited practices. Maybe, Jordanka, you could start with telling us what are these 8 prohibited practices and give us some examples, and we have a slide to share on that with the audience?
Indeed, yes. So the objective of the co-legislators was to set clear red lines and unacceptable practices that are incompatible with our European fundamental values and rights. And these are complementary to other existing also prohibitions. So this is very important to stress. We have broad categories, and the first one is the AI used for manipulation and exploitation of vulnerabilities that can distort people's behavior and make them and cause them significant harms. And here examples are, for example, for specific vulnerabilities linked to especially vulnerable groups like children or disabled people. For example, if toys are manipulating kids and incentivizing them to harmful behavior, or we, in relation to AI systems, deploying deceptive or purposeful, manipulative and subliminal techniques if we are, for example, interacting with chatbots that are deploying these kind of techniques, exploiting our cognitive biases and pushing us into behaviors that are significantly harmful, for example, for our physical safety or psychological harms. The other prohibited practices, the so-called social scoring, which aims to evaluate and classify people based on their social behavior or personal characteristics with over a period of time, with this score being used to unfairly and detrimentally treat these people. In particular, these could be examples where public or private also organizations, because it could apply to both, are using data from different kind of sources that are very unrelated, for example, for the purpose of evaluation, and they are combining this with detrimental consequences, for example, taking also specific unjustified action also to investigate certain citizens in case of fraud detection or other public mass surveillance practices. The next example is biometric categorization, where AI is used to deduce or infer from our biometric features, for example, our face, certain very sensitive characteristics such as the race, political opinions, religious or philosophical beliefs, or even our sexual orientation, which is considered unacceptable and not in line. And here we should draw a distinction, for example, with certain just AI systems used for labeling of data, which is not inferring this very sensitive characteristic or violating human dignity and our rights. And the next example is the use of AI for real-time remote biometric identification for law enforcement purposes in publicly accessible spaces. For example, this could be systems that are deployed in streets, public areas where we could be mass surveyed by law enforcement, collecting our data without appropriate restrictions and safeguards. So here, because of the risk of mass surveillance and very strong interference with our fundamental rights, this is also prohibited, but there is a careful balance that has been made between the co-legislator when the benefits of these systems could still outweigh the impact, and subject to strong safeguards. They could be in a very targeted way deployed for certain limited exceptions, like, for example, to prevent a terrorist threat or imminent threat to safety of people, or also to identify suspects based on known information for some of very serious crimes. And these exceptions could be relied upon only subject to very strong safeguards, including prior authorization by independent authorities, judicial authorities, and a lot of safeguards that should be put in place to ensure they are very targeted and not harmful. The next prohibition is when AI can be used to assess the likelihood or predict when a person would be committing a criminal offense based solely on, for example, our personal characteristics, such as, for example, nationality or certain origin, and this is without any link to objective and verifiable facts to criminal activity. So this is really to prevent this very harmful impact and use of these systems that are not aligned with fair justice systems and rule of law. But on the other hand, still use of AI when there are sufficient safeguards. This is just to support human assessment, and it is based on such objective facts linked to criminal activity would be still possible. The next prohibition is when AI is used to infer emotions in very specific context in the area of education and the workplace. And there are exceptions for medical and safety reasons. So in particular, the prohibition aims to prohibit use of AI, for example, if employees or students would be harmed when their emotions are being used and surveyed in these sensitive contexts when there is imbalance of power, while at the same time, with the exception for medical and safety reasons, still beneficial applications when this is justified could be allowed. And the final prohibition is when AI is used for the untargeted scraping of facial images from internet and CCTV footage to build facial recognition databases. So here the concept of untargeted is very important. Basically, these are, as an example, systems that are used to widely scrape all images on the internet to build these databases that are then provided to all kinds of deployers and that they can use them for further surveillance and identification of people from these databases. So here it's also important to draw a distinction between the biometric databases that are built and not just use of data for AI training, for example, and model development.
Thank you very much, Jordanka. Maybe a quick last question before the Q&A session, dealing with the consultation here again of the AI office, because it deals with AI system definitions, but also on AI prohibited practices. So it will help you draw up the guidelines on prohibited practices. Can you tell us a little bit about the result you already received?
Yes, that was also very informative, and we're very thankful actually to all organizations who have provided inputs primarily from European Union but also from abroad that have become very practical as examples for each of these prohibitions. What could be considered as all these different elements that should be always fulfilled and what further clarification should be given. For example, what is a subliminal technique, what is the threshold for the significance of the harm, or for example, what is a real time in the case of remote biometric identification. So very practical issues that we'll need to clarify, and also practical examples to put in the guidelines, because our objective is indeed to be very informative and illustrative, helping organizations in their daily work and issues when they are developing these systems, to know, have clarity if they would be in the scope or outside the scope. And of course, these are also just to emphasize also living documents that we are going to develop, because we are just seeing the implementation of this legislation that will also gather more lessons learned, more practical examples, and we are going, of course, to evolve and build this kind of use cases and knowledge also over time. But this has been a very important first step that will now inform our future work.
Excellent. Thank you very much. So we received a lot of questions. So maybe we can start, Friederike, with you. We have a question on AI systems definition, and the question is about the distinction between AI systems and IT systems. because it seems here for the person that the definition seems to cover some regular IT systems as well. Can you clarify this point maybe?
Yes, I can take a stab at this. I would also like to offer Jordanka if she wants to step in. From my understanding, the definition, the distinction here is really in the inference point. So giving an input and then doing that inference and inferring the output is the key characteristic of the AI system that your classical database recall or simpler recommender algorithms would do in a very different manner. So to my understanding, that would be the key differentiation, but also keen to see what Jordanka has to add if she would like to add anything.
Yes, I think clearly this concept indeed of inference and the different techniques that can be actually used to build this capability of the systems to achieve these objectives is the most important. And here also the recital of the AI Act has been giving, for example, the machine learning techniques, but also other knowledge and logic-based approaches. So it will be very important to distinguish just simple data processing, simple software, and automated system that do not have these capabilities and inference capacities.
Okay, we have maybe a more tricky question dealing with the timeline because we will have this obligation applicable in February 2025, but at the same time the enforcement scheme will not yet be applicable. It will only be ready in August 2025. So do we have something like an enforcement gap? That's the question here. What do you think of that, Jordanka?
Well, it's important to say that the rules will become applicable, and both providers and deployers will have to take measures to implement them. So in this sense, there is no gap, and that's why we are working also hard to also help collect these use cases, help organizations prepare and really make sure that they do not place on the market or deploy these kinds of prohibited AI systems. And already the Act is there, but these future guidelines will be also very important. In the sense also that this is a regulation that is directly applicable. Even affected persons who consider that there are systems that are violating the AI Act, they could also bring cases to court. But it is true that we would not have at this stage between February and August public authorities to actively start to enforce with fines or enforcement actions. However, it's just a short period and already as said, organizations should take action because these are directly applicable rules and there could be still civil liability consequences for them.
Thank you. It's very informative. Thank you very much. An interesting question deals with clarification, and I think that the purpose here regarding the territorial scope of application, the AI Act will not apply. That's an affirmation, but also a question. There is a doubt to providers from the EU placing AI system outside the EU.
That's correct, because the AI Act is a market-based legislation, so we are harmonizing internally the EU rules for how we regulate the internal market. For systems that are going to be exported outside the European Union, we have other regulations, including dual-use regulations and others, and that they become still, of course, enforced and applied to these cases as well.
Thank you. It's time now for us to delve into our second topic, general purpose AI. Maybe we will start with you, Friederike. Could you please explain the concept of general purpose AI model under the AI Act, and maybe also how this concept interplay with the concept of GPAI system?
Yes, I'm very happy to. So in the AI Act, we have the Article 3, that explains that an AI model indeed is a model that displays significant generality and is capable of competently performing a wide range of tasks. Now, this can be achieved, for instance, through training the AI model with a large amount of data through self-supervised learning. That is how large language models work. Again, you note that this is one option of how this significant generality and good performance at a wide variety of tasks can be achieved. So the legislation is somewhat future-proofed here. But that is then the definition of a GPAI model. It goes on to say that this can then be integrated into a variety of downstream systems or applications, and here is where the AI system part comes in. So again, going back to this to the example of GPT-4 and ChatGPT, GPT-4 or GPT-01 or whatever it may be is the model which can then be integrated into a variety of systems, such as the ChatGPT interface, so that you can chat to the model. Now, it's important to note that this is a functional definition. So a GPAI model will remain and be a GPAI model regardless of whether, regardless of the way in which the model is placed on the market. And yeah, I think then there's a bit more in recital 97. And again, this goes into examples of how these models are usually marketed nowadays. For instance, through APIs, such as saying application programming interfaces for people to build on top of the GPAI model, because ChatGPT in that sense is a particular example. You can't really access GPT-01 behind the ChatGPT interface. For that, you would have to go to the application programming interface, and then you can also build your own AI system on top of the AI model. This, of course, works even better with open source models, such as marketed by Meta or by Mistral. And here again, you see the distinction between the model that can then be integrated by a variety of different downstream providers into different types of AI systems.
Excellent. Thank you very much for these clarifications. Under the AI Act, GPAI models are subject to different regimes depending on their level of risk. Could you, Friederike, explain what are GPAI models with systemic risks under the AI Act?
Yes. So a GPAI model with systemic risk would be one of the most advanced models, which then has or is likely to have significant and large-scale impact on the union market, on society as a whole, and this would be over and above mere infringement on individual rights. So this is really a quite widespread impact, and as you note, it is tied to the most advanced capabilities. So this GPAI model with systemic risk would really be a small subset of all GPAI models that are out there, namely the ones that are at the frontier of capabilities and that are likely to have a widespread impact. Now, this technical criterion can be analyzed in different ways. Annex 13 of the AI Act provides some guidelines here. There is currently a technical criterion in here that is the floating point operations that are used to train the model. So above 10 to the 25 floating point operations, or flops, is where the AI Act currently stipulates one should assume that this is a GPAI model with systemic risk. Now, notably, if the provider believes that the model nonetheless does not have the most advanced capabilities, even though it is trained with this amount of compute, they could still alert the AI office to this fact, and that then could have the designation taken away from them. But that is the current threshold that is in there. There's also other criteria, such as the reach of the model, because going back to the initial definition, it is about the large-scale impact on the union market. This obviously is only achieved if there is a wide reach and a wide usage of the model. So this is another criterion that is taken into account. In the public perception, the 10 to the 25 floating point operations, the flops, has been very prominent. I think it is important to note that Annex 13 indeed also has other criteria for the GPAI with systemic risk.
Thank you very much. It's very important what you said. And based on this definition of GPAI models with systemic risk, I mean for the audience, it's crucial now to know who is in charge of the characterization of GPAI model, the AI office, the providers themselves, both. Can you give us some clarity on that?
Yes, so indeed there is two paths here. Per default, the provider would be obliged to notify the AI office once it becomes known that a model they are training will cross this threshold for systemic risk. That could mean that they are planning to train, for instance, with more than 10 to the 25 flops, and at this point they would have to notify that they are indeed in the process of training a GPAI with systemic risk. Now, it is important that the AI office understands at this point that this is what's happening, because certain risks from these GPAI models with systemic risk may indeed materialize in the development phase already. So this is an important point. However, the European Commission, as in the AI office, also is able to make this qualification ex officio. So where the AI office perceives that a certain model likely has systemic risk, even though the AI office has not been notified, the AI office could then make the qualification ex officio.
Okay, thank you very much. We now turn to the question of the legal regime of GPAI models. So here there is a two-tier legal regimes for GPAI models under the AI Act. We have a slide on that. Maybe Jordanka, you can start with the first level of obligations applicable to all GPAI model, and then Friederike, maybe you will go on with the second level of obligation. So Jordanka, you can start, and we will share a slide with the audience on the two-tier regime for GPAI models.
Yes, indeed. So the main purpose of these obligations that would apply to all general purpose AI models is to ensure transparency across the value chain. So as Friederike was explaining, because these are the models that can be integrated into numerous downstream applications, and this is important also for further compliance with the AI Act requirements, it is important that these models providers document certain characteristics, for example, the tasks, also the training data, the methodologies they have used, and specific information that they will have to keep at their disposal and give to the AI office as future supervisory authorities and also other competent authorities under the AI Act. There is also certain type of disinformation with another layer of transparency that they will also have to disclose to downstream providers who want to integrate these models into their AI systems. So that will help them understand the capabilities, the limitations of these models, and then they can also enable their compliance with the AI Act requirements, for example, for high risk, but also more broadly. And there are also certain types of obligations that aim to bring more transparency towards the public. These model providers will also have to publish a sufficiently detailed summary for the training data they have used in the development of these models. And this is very important also to enable legitimate parties with interests, the public, including right holders whose content has been used in the training stage of these models, to know and have this transparency that will help them and facilitate the exercise of their rights under union copyright law or other relevant laws. And we as the AI office are going to develop a template that will help providers implement this obligation in a consistent and uniform manner. And then there is also the final very important obligation is also that they will also have to put in place a policy to comply with union copyright law. So this is beyond also the transparency issues, including, for example, to implement appropriate measures for this compliance and also to respect opt-outs from the text and data mining exceptions. For example, if certain authors have reserved their rights when they have not agreed, for example, their works to be used for AI training. So this is also very important and complementary. So this policy is not changing the existing union copyright legislation, but rather aims to facilitate its implementation and make sure that the provider puts in place effective measures in its internal organization.
Thank you very much, Jordanka. So, Friederike, what about the second level of obligation for GPAI models with systemic risk?
Yes, indeed. So there is a second level of obligations, and it is important to stress that this applies or is foreseen to apply to a small number of providers of these most advanced models, which may carry fairly severe risks. Recital 110 lists a couple of them. So for this small number of providers developing and placing on the market the GPAI models with systemic risk, there are a couple more obligations, and these are outlined in Article 55. So briefly, what needs to happen here if you are placing on the market a GPAI model with systemic risk is you need to evaluate its capabilities. There is an obligation to fully understand what the model can do and how far advanced its capabilities really are. There is an obligation to conduct a comprehensive risk assessment of these systemic risks that the model might pose, and then put in place appropriate risk mitigation for each of the risks that have been assessed. So an example here would be you conduct a risk assessment, seeing that the model might be misused in order to commit cybercrime. It might write code that helps somebody to hack a critical system. Now you conduct an evaluation, you see whether the model indeed is able to write code of the complexity such that it might be useful in order to breach a critical system. And if you find out that that is the case, you will need to put in place risk mitigation, and this can take several forms. You could, for instance, prevent the normal user from accessing this capability and restrict user access to a slightly less capable version of the model, such that only verified and known users can access this very high capability that could be potentially misused, and similar approaches. But this is one example of this steps of evaluation, risk assessment, and risk mitigation. And then there are two more types of obligations: cybersecurity and incident reporting. Now, these are very important for the security around the model itself. So cybersecurity pertains to the fact that if you are developing and placing on the market this GPAI model with systemic risk, you are handling one of the most advanced AI models that are on the planet. Okay. And this is a very desirable thing for many people who might want to do dangerous things with your GPAI model with systemic risk. Hence, you have the obligation to harden your cybersecurity such that the model cannot be exfiltrated either through mishaps internally, where the model gains the capability to copy itself and it copies itself somewhere on the internet and then gets misused, or through theft by an external actor. So cybersecurity applications apply. And then there's incident reporting, and this is really the sort of bracket around all of this. If there is a serious incident from such a GPAI model with systemic risk, this has to be reported to the AI office. Now, this is simply to inform further policy development and further interaction with the model developer to understand, the incidents that are happening, even if they are internal. But if there is a serious incident, there is the obligation to then inform the AI office and, of course, national authorities where relevant. And those are the additional obligations for GPAI models with systemic risk. Again, this should only apply to a small number of providers that are really developing and placing on the market these most advanced models.
Thank you. It's very helpful. We can now discuss the drafting of the code of practice, which is currently being carried out on the basis of Article 56 of the AI Act. Friederike, how is this code of practice being drawn up, and what is the role of the AI office in this process? Maybe we can share a slide on that with the audience.
Yes, happy to explain. So the idea of the code of practice is that it should be a guiding document for providers of GPAI models for how to comply with their obligations. So this includes the transparency and copyright obligations that were outlined by my colleague Jordanka, and the second tier of obligations for general purpose AI with systemic risk that I just outlined. So for all of these, the code of practice will provide some guiding document for providers how to comply with these obligations. Now, the process of drawing it up is a very collaborative multi-stakeholder process. We have worked with over 1,000 stakeholders, ranging from individual academics, copyright holders, members of the society, to the GPAI providers themselves, industry associations, again, civil society organizations. So there's really quite a wide net cast here. Stakeholders have congregated into 4 working groups to focus on different parts of the of these obligations. And each working group is chaired by independent experts. So it is important to note that indeed the code of practice is being drafted by these independent chairs, not by the AI office itself. And the role of the AI office merely is to facilitate this process and to ensure that the timely delivery of a final draft of the code of practice, which would then be given legal validity via an implementing act. And providers of AI models would have to sign up to this code of practice in order to use it to demonstrate their compliance with the AI Act. So this is the multi-stakeholder process that we are running through. You can see the timeline for it on the screen. We have published the first draft of the code of practice on the 18th of November, so everybody can see it online. And we have received over 400 submissions of feedback on this and held multiple verbal and written interactions with different stakeholder groups, including providers, but also civil society and other members of the working groups, and are now gearing up to publish a second draft of the code of practice. And then this will continue until in May the final draft is expected. And then, as I said, providers will have the opportunity to sign up to the code of practice and use this to demonstrate their compliance with the AI Act.
Thank you very much. A last quick question, but very important one, maybe for you, Jordanka, still on the code of practice. What will be the legal effect of this code of practice? The code of practice will be mandatory or not? I mean, the industry need to know that.
Of course, that's a very important point, and it's important to clarify that this is a voluntary code of practice. So that's why this collaborative process where providers are involved and also other stakeholders is so important. We want, of course, the providers to sign the code and rely on it for future compliance, but it is in the end a voluntary mechanism to which they can sign. And as explained by Friederike, we as the AI office are going to assess the code once it's finalized in May, whether this is fulfilling an appropriate tool to implement the AI Act obligations. We'll do that together with the AI board, and if this assessment is positive, which we truly hope, and we work so hard together with all stakeholders to lead to that outcome, then we can approve this code through implementing act and give it general validity. So all these providers who sign to the code afterwards will be able to rely on it to demonstrate compliance. But other GPAI providers could also use other means, so it's still is a voluntary tool. In that case, they will, however, need to show that they also are implementing good enough solutions and measures to effectively implement the obligations under the AI Act as well. So we, in our role as the future AI office supervising, will monitor everyone, and that has to be clear.
Thank you. Thank you. So now we have our Q&A session. So I'm reading already some question. Maybe I have one important question on enforcement and governance for you, Friederike. So the AI office will be in charge of enforcement of GPAI models, and the question deals with the relationship here between the AI office and national authorities when governing these GPAI models.
Yes. Yeah, that is a very important question indeed. So in the case of GPAI models, the compliance with the provisions under Article 55 that I outlined, so evaluations, risk assessment, mitigation, cybersecurity and incident reporting, the compliance for GPAI models with systemic risk and for GPAI models more generally is enforced by the AI office. So on this model level, the AI office is really the competent authority. And then the obligations on AI systems are enforced by the competent authorities in the member states. So that is the distinction here.
Thank you. I have also a more technical question. So still for you, I think, Friederike, we need some clarity on the concept of fine-tuning of an AI model. So what fine-tuning of an AI model would entail? And is it the change of the parameters of the model here?
Yes. So I think the important thing to note is that we are working on a guidance on this. So there will be more information in due course. Maybe just to briefly explain the concept of fine-tuning. This is really about the moment where a model, such as a Mistral or a Meta model that is open source, can be taken and can be provided with further data and then fine-tuned based on this further data to augment certain capabilities of the model. So it might be, for instance, fine-tuned to respond in a certain dialect. That would be a classical case. And there is an obvious and very important question here is when does somebody who is fine-tuning a model become a provider, and which obligations do they then have to comply with compared to the original developer of the underlying model. And as I said, we are working on guidance on this.
Thank you very much. We are a question on ChatGPTs. We talk about ChatGPTs already, but here the question mentioned that the AI Act was negotiated before the rise of ChatGPTs, and so it does not exactly fit with the risk pyramid that we all know. So the question is, why was this not fitted under a limited risk AI? So maybe Jürgen or you, Friederike, I don't know.
Yeah, so maybe just a point of clarification. After the Commission made the proposal in 2021, we had a very intense process of negotiations with the co-legislators, and at that time already the GPT and these very impactful capable systems were already emerging. So already the co-legislators, both the Council with the Member States as well as the European Parliament, have examined and very thoroughly taken into account how actually to further improve the Commission proposal to take a proportionate approach with specific rules that are also future-proof enough, as we are seeing that they are very fast evolving, and the further detailing of the code of practice and the mechanisms through which you implement these obligations were very important. So it is reflected also with both ChatGPT, but also the impactful models that are powering these many applications in the approach in the legal rules. So that's why we have both rules for the systems, the applications, but also the powerful models, and they are very closely interrelated in the overall scheme, because we should not forget also the different layers and also specificities that, the high risk also AI systems, the way they are designed, they can be also further reviewed and updated over time by the AI office. So it is really embedded in the architecture of the AI Act to have this future approach to adapt the rules, both in terms of the types of systems, but also the implementation measures that should be taken to comply with the different requirements.
Thank you very much. I think it's time for us to start our third topic this afternoon, and it deals with requirements for high-risk AI systems and the related technical standardization process. Maybe we will start with you, Antoine. Could you start by recalling us the main rationale of these requirements for high-risk AI system? What are they about? What was here the inspiration of the EU legislator, please?
Sure, I can. Let me, for this, actually give a bit of historical background. Also to understand exactly why we ended up ultimately with these specific rules in the AI Act ultimately. So the European Commission and the DG Connect in particular, actually, we have been actually for years now trying to create an ecosystem of trust and excellence when it comes to AI policies. And actually following the first communication on AI, which was released in April 2018, we have established a high-level expert group on AI, which was composed of 52 representatives of civil society, academia, and industry, to make recommendation to the Commission on how actually to address and handle opportunities, but also potential risks brought by AI technologies. The overall work actually of this high-level expert group has been very crucial in the making of the European Commission's approach to AI. Some of the major elements which were put forward by this high-level expert group, such as, for instance, the concept of trustworthiness, or the 7 key requirements which were actually mentioned in the ethics guidelines, which is a document that was published by this high-level expert group, really served as baseline, I would say, for the Commission's approach to the drafting of the AI Act proposal. Subsequently, actually following these activities of this high-level expert group, but also following a broad public consultation that was organized in 2020, the Commission decided that the best way forward, actually the best way to rely on the opportunities brought by these types of technologies, while at the same time handling the specific risk, was through the adoption of what we called hard law. Then what followed was really a reflection on how actually to translate these generic principles into a European legislation. And that's when the Commission took actually several very important regulatory decisions. First, it considered to follow a product safety logic and actually to consider AI systems as products. So this is first very important regulatory decision. Second was actually that in order not to put too much pressures on providers of AI systems, we would go for a risk-based approach, meaning that we would actually impose only obligation to those AI systems that poses risk to health, safety, and fundamental rights. So all of this actually was a bit our journey together with actually the broad community that actually brought us, if I may say, the different requirements that are highlighted in the legislation for what concerns high-risk AI systems, which covers things like data quality, data governance, human oversight, robustness, accuracy, and others.
Thank you very much. And maybe now a more practical question for the AI organization: how these requirements interplay with the conformity assessment regulatory scheme under the AI Act, Antoine?
Yes, so first, it's always good and important to keep in mind that the first regulatory decision I was explaining, which is that AI systems are considered under the AI Act as products. Now, based on this fundamental decision, what we used for most of the provision of the AI Act, actually notably for the provision that relates to high-risk AI system, is a regulatory approach, which is called actually the New Legislative Framework Approach, or NLF approach. This specific approach is actually a very common approach in the European context. It has been actually developed for dozens of years now, and it is really putting actually as a central element products and the safety of products which are put on the internal market. It is actually used, for instance, in regulations such as the ones which regulate the use and the put onto the market of toys, of medical device, or of, for instance, radio equipment materials. This regulatory approach has key actually features. One of them is that it mostly focus, or actually it implies that the legislation will mostly focus on high-level essential requirements, while the translations of those requirements into practice will be left or will be co-decided in a specific multi-stakeholders forum for discussion, which is standardization. The second main feature of this regulatory approach is its reliance on a conformity assessment procedure. So this basically is based on internal controls, technical documentations, and for instance, the creation or the establishment of quality management systems that allows actually a producer, before a certain product is put on the internal market, to get a CE marking that actually presume that this product, in our case, that the AI systems, is compliant with the European legislations.
Yes, thank you very much, Antoine. So you mentioned this conformity assessment based on quality management system and technical documentation. So in this case, a notified body should conduct the conformity assessment of the AI system. So maybe Jordanka, the audience, may wonder who are these notified bodies, and can stakeholders choose them freely? Can you help us?
Yes, so the notified bodies in essence like 30 independent parties whose objective and task is for certain types of high-risk AI systems, in particular those that are already embedded in regulated products, because this is how we do not touch any AI system in a product, but only those that are safety component already subject to this third-party conformity assessment with notified bodies as high risk. Or there is also the other example of remote biometric identification systems that would be required to go through these notified bodies to have this independent check based on their quality management system and documentation, how they have fulfilled the requirements. And there is a specific procedure under the AI Act with national notifying authorities that will have to notify these bodies who have the necessary expertise, but also satisfy other conditions like independence from the provider, internal control, security procedures, and others. So they will have to comply with these, and after this notification procedure and that they become recognized notified bodies, providers in the whole European Union will be able to select whoever they wish to perform their third-party conformity check. Like this could be even not needed to be in the country itself, but as long as they are such notified bodies in other countries, they can freely choose and use their services.
Thank you thank you very much for your response. Let us move on to the standardization now. This is a very important dimension of the AI Act. So all the requirements we mentioned earlier are intended to be translated into technical standards in the European format of harmonized standards. So this is Article 40. Antoine, could you explain how does it work? So what are harmonized standards in EU law first, and how will Article 40 of the AI Act be implemented?
Yeah, so first, really the important elements is these harmonized standards. So harmonized standards are actually technical documents which are developed by recognized standardization organizations on the basis of a mandate from the European Commission, which, if evaluated positively by the Commission and mentioned in the official journal of the EU, would grant a presumption of conformity to a provider that is adopting that specific standards. So basically, this standardization process has been actually very much linked and used in implementing product safety legislation in the European Union. As I mentioned, actually, we have lots of examples of previous legislation which are based on the same types of implementation process. What is important is really that this specific regulatory approach and the reliance on these harmonized standards, which is actually a voluntary reliance, provider of an AI system could still, go his own way, but harmonized standards are really there to help him actually comply with a specific legislation. This specific process and this specific reliance on these standardization activities was foreseen in order to make sure that actually the rules from the legislation would be practically implementable. And so that's why we are often referring to the fact that it is a legislation which is putting rules on providers of AI system, but it's actually very much forward-looking, and it's actually very much innovation-driven, because ultimately, the people that will be translating the high-level requirements into practice are the ones which are able actually to contribute to these specific technical documents which are harmonized standards.
Thank you very much. And can you go on and tell us who are in charge currently of drafting these harmonized standards for the AI Act?
Yes, so as I mentioned, actually for standards to become harmonized standards and to actually ultimately grant a presumption of conformity to a company using it, it needs to be based on a Commission mandate. In the jargon, we are calling this actually a standardization request. In the case of AI, DG Connect has been actually very much following and involved in the AI-related standardization activities for years now. We have been following closely the work ongoing, the technical work ongoing at international and European level. And we have been actually very early on, which is very unusual, very early on adopting a standardization request to ask European Standardization Organization, and in our case, CEN and CENELEC, to develop standards in 10 different areas which are actually directly linked to the different requirements for high-risk AI systems. In addition, in this specific mandate, so in the standardization request, we are also suggesting or imposing certain specific rules on the procedures for the standards making process, notably relating to the proper involvement of civil society experts in the standardization activities, but also to the need of making sure that the standards being developed are fully aligned with the objective of the legislation, which are, among others, the protection of fundamental rights. And so these are also elements which have been specifically mentioned in the standardization request. One last element is that actually we are requesting European Standardization Organization to come up with harmonized standards. That does not mean, though, that standards being developed at international level cannot be used or taken into account. That just means that those specific standards that are developed in other types of international standardization fora needs to be aligned, and needs to be aligned not just with the approach, but also with the taxonomy, for instance, and the definition that we are using in the European legislation. But there are some standards which are being developed at international level, which serve actually as a very good baseline for the practical implementations of the requirements of the legislation.
Thank you very much. You mentioned already a little bit the role here of the Commission and the AI Office in this standard setting process, but could you maybe give us a little bit more insight of the role of the AI Office? Does the AI Office have a form of monitoring role here in the current standards setting process, Antoine?
Yes, so as I actually mentioned before, we have been very proactive from the Commission side, and in DG Connect we have been involved actually in these standardization activities for a long time. And why actually we have been so much involved? Because given the overarching nature of the legislation, but also given the risk and the opportunities, we were actually considering that there was a need to ensure that the technical experts which are in the standardization activities would understand the approach taken by the European legislator, and also it was actually allowing us to react very fastly on certain specific assumptions that were taken by technical experts. And that's why actually we have been very much involved in that specific process for years now, and that's why also we will actually continue to be that much involved, and indeed, as you mentioned, monitor the creations of and the developments of these technical documents to ensure actually that ultimately we ended up with practical documents that would allow providers of AI systems on which specific requirements fall to be able very early on, to comply with the requirements of the legislation.
Thank you very much. A last question before our Q&A session, a very concrete question. Do we already have technical standards on AI in the EU jurisdiction, Antoine?
Yes, so actually I was mentioning the fact that there has been actually standardization activities ongoing for years now at international level in two international standardization organizations called ISO-ISC, in a special committee which was created just for that, called the Special Committee 42 since 2017 actually. And then we have also discussions which are ongoing at European level in CEN and CENELEC, and especially actually in a joint technical committee called JTC 21, which is also since 2021 developing different types of standards. So at this stage, at this moment in time, we do have actually specific AI-related standards which have been developed at international level. Nonetheless, actually not all of directly usable as is in the European context, notably given that they are not directly, first, neither nor useful nor directly aligned with the approach of the legislation. Still, there are, as I already mentioned, good baseline, and here I want to stress, for instance, standards such as transparency taxonomy of AI systems, which is actually a good baseline for also the discussions ongoing at European level. Then in the European context, as I mentioned, we started later, we started in 2021. We have very good progress, and we have actually seen in the past few months these standardization activities rapidly evolving. And we will, as I mentioned, continue to monitor closely to ensure proper adoption of these very easy to implement, if I may say, technical documents that would facilitate the compliance process of high-risk AI systems provider before the entry into applications of specific high-risk AI requirements.
Thank you very much, Antoine. It's time for our Q&A session, and I have one precise question on requirements. So maybe Antoine, concerning the list of requirements under the AI Act, the question is asking, do we have something related to sustainability?
Sustainability is not directly actually mentioned in the initial standardization request, but sustainability and actually standardization deliverables relating to the energy consumption of specific models and systems is something that is mentioned in the legislation. So in the future, we will be actually publishing new standardization requests that will ask for standardization deliverables directly linked to the energy consumption of specific models and systems. And this is actually a requirement of the legislation.
Okay, thank you. I have a question maybe for the three of you. The person here is saying that he often hears that the AI Act will slow down AI development in the European Union. So what arguments would you have here to say otherwise? Who want to start with some element? Antoine?
I can take it, yes. So basically, as I mentioned, given the specific approach taken in the European context, we really tried actually our best to be innovation-driven rather than actually hinder innovation. It's also important to always remind ourselves that this is only one part of the European strategy. So the creation of an ecosystem of trust is one side of the same coin. We have also the creation of an ecosystem of excellence, which we have been actually building for more than 6 years now. Now that the legislation has been finally adopted, we will, as the Commission, really focus on this, making sure actually that we can get the best from the technologies and we can actually get competitiveness gains in specific sectors when it comes to the use of these specific broad set of technologies. So 2 elements. First, the legislation is actually protecting against the risk, but is actually based on a regulatory technique which is very much innovation driven. Second element, we will now have actually the biggest part of the work of the Commission will be on promoting actually the use of AI technologies in the internal market. But perhaps Jordanka wants to complement as well.
Yes, maybe I could complement that. The AI Act and safe regulation is also very important for innovation, for the uptake, for trust of both deployers but also citizens. So we are really taking the benefits of these technologies, while, as Antoine mentioned, with the very targeted rules focusing on really the risky applications, having appropriate and proportionate mitigations, while also giving the practical tools for companies what to do in practice, because we've seen that indeed this lack of legal certainty has been, even before that, preventing the development and uptake of these technologies. And the AI rules and requirements with the standards, with the code of practice, are actual enabler, helping organizations how to develop more transparent, more safe, more non-discriminatory systems, and really tackle these really harmful outcomes that will not allow us to benefit from these technologies. And maybe just another point, that the AI Act also has very targeted and specific tools to enable the safe innovation and development, including measures such as specific support measures for small and medium-sized enterprises, also regulatory AI sandboxes that will allow developers to have dialogue, support, legal certainty, and also safe environment to develop those tools, and also other supporting measures, including through standards, guidelines that we are aiming to bring now and enable the effective implementation and wide uptake and availability of these systems also.
Thank you very much, Jordanka. We still have a lot of questions, but unfortunately our time together today is coming to an end. Thank you very much for all the questions on the Slido application. So I would like to thank again the speakers for the time and excellent contributions today. Really, it was enlightening, and we have covered three complex topics. So, obligation applicable to February 2025, regulation of GPAI models, and mandatory requirements for high-risk AI systems, and the related standardization process. But this two-part webinar is only the beginning of the AI Act exploration. So in 2025, we will delve deeper into these topics with additional sessions, and we will focus on different areas, still of course on obligations and requirements, but also other topics such as ethical considerations in AI, GPAI, open source models, and also a sector-specific application of the AI Act. Also, please help us to prepare the future seminars in filling in our satisfaction survey. You have a QR code displayed on your screen right now for that. So thank you very much. And okay, it's time now. So thank you again for your attention, and we look forward to further exchanges.
Thank you.